We now get to Dina Scott. I think Dina Scott might be light relief. I really don't know. Dina Scott, who, just for everyone's benefit, could you explain what Dina Scott's job was?
She's a coordinator for the finance department, Perth and Canals Council, who deals with care packages and the financing it. That's her job. Okay. She's the one that you send all your paperwork into. She records everything, and then you get a wee letter for her saying, okay, you're fine. That's her job. Only met her, I think, I know the time was a carer twice.
Okay. So you're cross-examining her. You say, could I bring you to number 6 in your affidavit? You said, quote, sometimes decisions were taken in relation to John Jr.'s welfare under the guardianship powers that were what John Sr. wanted, not what was best for John Jr. Could you explain a wee bit more, what you meant there? Right. This is a financial a financial accountancy person who's never met John Jr.
No.
But she's saying that your decisions are not in his interest because somehow she knows. Well, that's interesting at least. Her response was, I think just what I was saying. Do you notice the backing off?
Yeah, I think
just what I was saying. So she's backing off the statement that I'm not quite sure whether this is purely based on the receipts and things, the spend that we had, and John going out all the time was always in the best for John's best interest, purely because of the weather. He didn't seem to be meeting anybody else, people of his own age, or join groups or anything. Right. So she's made a statement. Essentially, I'm the financial person, and you're not. You're spending money in your best interest, not in John's. That's a big statement. That's a serious criticism.
Yeah.
You ask her about it, and her response is, well, maybe it was raining sometimes when they went out. That's it.
Her job is finance. If there was fraud, corruption or whatever, that's her job. She's meant to do it. Why they brought her in to make statements that she knew nothing about, I really cannot figure out for the life of me what she was doing on that stand. Well,
she was certainly there to try and do a number on you, so it didn't go well. So here we've got your question about, she made a statement that your approach to involving MSPs and councillors in disagreements with Perth and Kinross Council was wrong. Right. You asked that it took my MSP 7 years to achieve my son's care package, as you know, and he took part in meetings to get that agreed. Is it not a good thing that there's MSPs and councillors who actually fight my case if I'm not happy with what the local authority is putting across? That's what happened, and we got it at the end of the day. It wasn't me sitting down with countless social workers and getting it done. Did it not take people like the MSPs to get involved? That way they got to know what it's like being a parent, trying to access a care package from a council. Do you not think that would make me a bit, not abrupt, but forthcoming in trying to fight for what I was wanting for my son? Now, this is, I mentioned before, people lie, right? The fact that you got a verbatim recorder here, writing down every word, they write down even when the words, and they stop themselves saying what they're going to say and say something else. So she says, I don't think you should have gone to MSP, it's not the best way, when they don't actually have the know-how of, how things, and what she was going to say, I believe, is work, right? Because we have a system, this is how things work. So you realise that that was a really bad thing to say because it would show how officious they are, and she wound it back in. So what she actually said was, they don't have the know-how of, how things, what's really best for John. So she swerved there. How things work was changed to really best for John. So she's modifying her position because what's happening inside the council and what they're meant to do are two different things. And she was kind of caught out there by your cross-examination.
See, one of the things you've got to remember as well is her working for the council, her job is to save money, no spend money.
Yeah.
If she can see a way of saving a bob, she'll do it. The fact that you bring an MSP in, you know, why would they start an organisation like the Scottish Personal Assistance Employment Network to go out and speak to families, to put care packages so that people with learning disability children can get the help and involved with their families? That is what is meant to happen. But as I've said to you all along, when you're dealing with local authorities, it's a different ball game. No, local authorities are only there for one thing, saving money the best way they can.
So under cross-examination by the solicitor from like Jimsy and Jennifer Shields, Dina Scott stated she did not think the timeshare in Aviemore was an appropriate use of public money. So again, the suggestion is you're misallocating funds. Yeah. So you picked this up. You said, I picked out a timeshare for him on the basis that it was Helen Winter who said it would be a great idea to use his money so that John got a holiday every year. And was that not a good idea? Right? So Dina Scott is now put on the point of having to defend what she said in her affidavit. And she immediately folds. She says, I'm not saying it wasn't a good idea.
There you go.
Right? But I did think at the time, I did ask about that at Aviemore because I didn't realise that it was to be allowed for public money to buy a timeshare for anybody. Okay? Now, public money can go to holidays and you're actually getting a more economic holiday than you would have otherwise got, so...
Well, put it this, like, John was spending in between, I'd say, £2,000-3,000 a year in holidays. He was getting 2 or 3 holidays. This timeshare was costing £3,000, and that's it paid for a year. You know, for every year for the rest of his life. The only thing he's got to come out of that now is, like, he's got a maintenance charge, which everybody has to pay when you know, back then, it wasn't a lot of money for the maintenance. No. So, Helen Winter, who I'd sat down with, she done the figures, no me. You know, she was the one that agreed for the money to be spent. You know. Well,
you said that. You said Helen Winter agreed it, and Dina Scott said, I know that.
Well, what was the argument then?
Right. So you asked her, you said, do you not think a holiday for John and Aviemore would be a good idea? And then you're saying something about it. You didn't know whether public money could be used to buy a timeshare for anyone. She said, yes, a holiday for respite. That's what happens generally. But to actually use public money to buy a timeshare, I felt it was inappropriate. You said, that was allowed by my social worker at the time. She said, of course, that's right. You continue, she allowed me to do it. Is that not true? She said, that's true. That's also why I questioned, because I wasn't sure if it was correct. I was doing my job, and I guessed that Helen Winter was doing her job.
What was that argument about?
Right? So you continue, to be perfectly honest with you, I don't know what the outcome of that was, whether it was allowed or whether it wasn't. By the time it was already paid, it was in place for John, it's for a yearly holiday, and as you say, you're not sure what John got out of it. Well, that's a holiday he gets out of it. He enjoys himself. He's out with his carers, 7 days up in Aviemore. You couldn't have a better place for a boy to go on holiday. Is there something wrong with that, or is he not getting something out of it? She responds, no, I'm sure he's getting a lot out of it. So essentially, she'd raised this as an issue, including in her affidavit. Yeah. Not just, I was worried back in the day. In her affidavit, and you showed that there was nothing there.
But you've got to remember as well, here, right? We've got a council, I've got a package for John worth £96,000. I never used more. I think the most amount of money in a yearly thing for John was £54,000. So I saved that council per year £42,000 a year. And off of that, I'm paying a timeshare maintenance bill for a month.
Yeah.
A £3,000 holiday covers, well, I think it was nearly £4,000 holiday covered John for the rest of his life. And as I said, if Helen Winters, and I'd got Helen Winters to stand on that court stage, she would have destroyed Dina Scott.
So further down the cross-examination, you say, could you go to number 19, please, Miss Scott? At the bottom of the paragraph, I think the solicitor for Morrison's there actually stated John was not nice and he often talked badly about staff, the council, any kind of authority on the phone. You say, you and me have had lots of talks on the phone and we chatted and you knew I was angry with a lot of stuff that had been happening to John. Would you be expecting me to be talking so nice about the council? She responds, no, I understand what you were saying. You said you and me had a great rapport on the phone. Let's be honest about it. She said we did. So there's no problem.
There isn't, there never was one.
You said, how long did I have the care package? She said, I honestly couldn't tell you, some years now. You said, was there any time in those years when I was actually asked, what are you doing with the money? Have I done something wrong with it? Have I been pulled in and said there's thousands of pounds missing? Did that ever happen? Dina Scott said, no. Right? So all of this mudslinging about money comes to nothing.
That's what this guardianship court proceeding was all about. There was nothing there for anybody. It was a waste of taxpayers' money. It was a waste of my time. The pressure put on me for this.
Well, it shows they didn't have a case, and by here they were trying.
When you see it in writing, David, it's worse.
Yeah. So we come to the testimony of Shirley Douglas, social work team leader with Learning Disability and Transitions team, Perth and Kinross Council. So, first, cross-examination by solicitor for Jennifer and Mrs McJimsey. He says, in paragraph 4, you provide some information which is specific to Anne Robson. Do you know why she felt stressed working on this case? Answer, I think she felt intimidated by Mr. Shields. I think that the stress ultimately led to her asking for a demoted role. She applied for a demoted role. Now, we've previously spoken about Anne Robson, the pressure she was under from Perth and Kinross Council Social Work Department, and she was crying at a meeting, and you comforted her. And the fact that Perth and Kinross Council concealed her contact details from you to prevent her being at this hearing and actually giving evidence. So she's not there, so they can now say, well, it was John Shields that made her upset. This is nonsense. Would you like to say anything more about this particular smear?
Anne Robson, they nearly destroyed the woman. You know, as a social worker, I've heard a lot about her. I heard about her case. A lot of people liked her. She never had any bad comments for social. I ever heard of organisations I was involved in. But they went out their way to destroy this woman. You know, there is no more I can say about her, is the fact her employers tried to destroy her. Because all she wanted to do was help the people that she represented. And at that time, the bullying was going on at the council.
Well, this is it. I mean, it made the press.
Yeah, it made the press.
Bullying at
the exact same thing. I don't know who it was. It was somebody sent me the bullying. It was in the paper. Bullying Perth and Kinross Council. It was the exact same time as Anne was trying to do John's care package.
The cross-examination by the lawyer says, you make reference to an incident which was alleged to have occurred in 2009. She says yes. And that's the alleged assault by Mr. Shields upon John. Yes. Lawyer says, now it's my understanding of this paragraph is correct that whatever happened was witnessed by a single personal assistant. Is that correct? Yes. That is a lie because the police concluded it was malicious, so it wasn't witnessed by anybody because it didn't happen. Lawyer continues, and that was taken no further for lack of corroboration. Is that correct? Yes, she says. Now, again, that's false. The police had investigated and concluded it was a malicious allegation. So again, smearing, lying, misleading the court, not great.
It's all they can do. It's all they've got, David.
It goes on, right? So the lawyer continues. So in fact, from your paragraph 6 of the affidavit, was Jennifer Shields acting as a sort of go-between, almost, between the personal assistants and your office? Yes, she was. Now, this is very significant because here you've got Jennifer Shields. She's actually operating as the professional representative of the personal assistants.
Yeah.
She's feeding information in, and she's the point of contact, not them. They're not gathering, the social work department aren't gathering information. They're being fed information by Jennifer. They're lapping up, they've got itching ears, but that's what's happening. It continues, there's just one point in paragraph 6 I want to clarify. You refer to the staff stating they were getting sore backs. What do you mean by that? She said, that was in relation to the amount of time they had to spend on John's bed. I think the biggest concern at that time was lack of activity that they were being afforded when he was spending most of his time, the carers alleged, in the house, and they were having to spend most of that time in his bedroom with him. They were getting sore backs as a result. This is Perthink and Ross Council, people pushing this. We'll come to why they know that's a lie shortly enough, right? But they're pushing this line again that John never got out, which was one of the allegations that came from the carers and was clearly contrary to the records. Okay. So the lawyer continues, can I refer you to paragraph 10, please? Paragraph 10, you describe a visit that you made to Mr. Shields at his home. You write in the third sentence, Mr. Shields became very angry at this point and stated that he was going to contact his solicitor. A wee bit further down you write, I advised that we would prefer for his son to remain living with his mother whilst the investigation was ongoing. Mr. Shields refused this and stated that his son would be coming home that day. Was Mr. Shields' manner towards you during, what was Mr. Shields' manner towards you during that meeting, please? He was very angry. His voice was raised. Right, okay. Couple of things about here. One, she records that you specifically denied permission for your son to go to his mother's. Their position is the reason he's in his mother's at that very moment is with your consent. Right? So that doesn't make any sense. And secondly, they've just told you that they're due to false allegations that they're not allowing your son to return to your care. You raised your voice. Like, no wonder. What do they expect? Right? And this comes up a lot. With social work seem to think that people must be superhuman. They must be detached and unconcerned. Of course, if they're detached and unconcerned, that's a problem because they're detached and unconcerned. If they're passionate and they're involved, that's a problem because they're passionate and they're angry. And the social work make the decision and then the family is in the wrong. By definition, right? There's no justification for this. It's just how they think. Lawyer continues, can I take you to the end of paragraph 10? During this whole meeting, I felt that Mr. Shields was not listening to me. He asked the police what they had to do with it.
Good question, though.
Yeah. Once again, at the close of the meeting, what was his demeanour towards you? I mean, he remained very angry throughout the whole visit and told me to get out of the house on several occasions, but I needed to tell him why I was there and to be clear about Perthink and Ross Council, what Perthink and Ross Council were going to do next, given that he had not agreed for John to stay with his mother. Lawyer continues, do you think that John could have been prejudiced or harmed by being present while this investigation was ongoing? She says, well, yes, serious concerns have been raised to us, and we ultimately were concerned about John's welfare and protection. Again, I don't accept that's at all a reasonable statement. Lawyer says, would it have been reasonable for Mr. Shields to say, all right, while this is going on, John can stay with his mother? Do you think that would have be a more reasonable stand? She says, I do. Do you think in demanding John's return, Mr. Shields was again failing to prioritise John's welfare? She said, I do. Lawyer continues, you discuss applying for a removal order, which I think in the first instance was refused. Now, I talked about the strange things people do with language when they're nervous. This is the lawyer doing this. You discuss applying for a removal order, which I think, right, he's trying to back off the fact. He knows
it was refused.
It was refused. I think in the first instance, which implies that there was a second instance when it was not refused, but that's not true. So he's trying to squirm that sentence to distract from the court understanding that they went with all the allegations in front of a judge, and the judge says, you're not on, get lost, and they're before another judge, and they're trying to hide that, right? Do you discuss applying for removal order, which I think in the first instance was refused? He's trying to qualify what is an unqualified statement. She said, it was, yes. Lawyer continues, you refer to 2 telephone calls that were received by your department from Jennifer Shields, I think. She responds, 2 separate telephone calls, yes. I only received 1 phone call from Jennifer Shields. And that was that she had spoken to her dad on the phone following my conversation with her. And just as it states that he had been abusive to her on the phone, allegedly, and that he had demanded his son was coming back up the road immediately. The next telephone call was made to out-of-hours service at Perth and Kinross. Jennifer had been in a distressed state, having dropped her brother off with her father, and notified out-of-hours of that. Okay. So, that's an interesting little data point, because we'll come to more on that. So, when Jennifer they went to court and said, we've got all this information against John Shields. He's a bad man. We need to immediately remove his son. The court said, you're not on. You haven't satisfied risk of significant harm. You don't have a case. Go. They then said, right, firstly, right, they're saying that there was a phone call from Jennifer that she had spoken to you on the phone. You've been abusive to her and demanded that your son be returned. Do you remember that phone call? Yeah,
it was never abusive. Because Jennifer was asking me what was going on up in Blair, and that, to be honest with you, I hadn't a clue what was going on. I didn't know the police thing. The only thing I knew was a phone call for Shirley Douglas telling me that John was getting brought back up the road, and me and Jennifer had a talk, and I said, right, get John back home, blah, blah, blah. That was it.
Right, okay. So, she then brings him home. She then drives off. But on her way home, phones out of hours at Perth and Kinross in a distressed state to notify them of it says that, but presumably only that can be is her distressed state. So she stopped on the way home and phoned out of hours again, having returned him on the Monday. She's not even gone home, and she's again on the phone to PKC out of hours, trying to stir up more trouble.
Well, I've got to be honest with you, I don't know about that. The phoning Perth and Kinross Council. The only thing I know my daughter did was when she brought John home and we had a confrontation outside where she was going on about, she was worried about John coming into my house with the state I was in, which I was getting heated because my daughter's accusing me of everything and she thinks I know everything that's going on and I don't know a thing. And I had to turn around and stop and say, look, I don't know nothing here. I've been told absolutely nothing. I says, 1 minute John's getting kept away from me, next minute he's coming home. Then I'm getting a phone call telling me about a court proceeding. Then I'm getting told, oh, John's coming on because the court proceeding was thrown out. I says, then you're bringing him up the road and you're standing out here and you're shouting at me and Janice concerning what went on that day, wanting to know what was going on up here. And I told her, we don't know nothing. Social work told us nothing. Like, I go back to as a guardian. I went through that in a 24-hour period as a guardian. And what do I know? Nothing. Not a thing has been told to me.
So, the lawyer for Jimsy and Jennifer Shields continues. They're talking about the interaction between Shirley Douglas and your daughter Jennifer. Said, and she, Jennifer, described in particular, I've read your affidavit, she described an altercation with her father, yes. And she described that John was upset by that, yes. Does this conversation indicate who was responsible for the altercation? Clearly her father was, from what she indicated.
Yeah.
Right? Which the court should give zero value to, because this is just he said, she said. And in the circumstances, John was upset, yes. Does it appear to be another occasion when Mr. Shields found it difficult to prioritise John's well-being in a particular situation? Yes. Okay, she said yes. Now, I would point out that if it's Jennifer's behaviour that is generating the altercation, then that is an indication of another situation in which Jennifer is not prioritising John's well-being. Okay, it works both ways. Right, so you continue cross-examination and you ask her about the removal order and the application to the court. You say, yeah, what were the concerns given to the court? She says, 3 allegations of physical assault and an allegation of neglect. So Shirley Douglas was then asked what Sheriff Fowlis had said. She replied, my understanding of that day was that the sheriff did not feel that the concerns were serious enough in terms of the legislation, very specific legislation, which is set out in the terms of the Adult Support and Protection Act 2000 to warrant granting a removal order. Okay? This, again, right, is weasel words, because what did Sheriff Fowlis say? Sheriff Fowlis said no, right? It's not a long answer. Sheriff Fowlis said no. Sheriff Fowlis said that they hadn't met the level of risk of significant harm. As there was no risk of significant harm, there could be no removal order. That's what the sheriff had said. She's saying, and it's the weasel nature of the words, right? My understanding of that day, right? So I might be wrong. So she's trying to back off. She's trying not to tell the court what actually happened. My understanding of that day was the sheriff did not feel. It's just a feeling. No, the sheriff decided.
That's right.
He didn't feel that the concerns were serious enough in terms of the legislation. I mean, they were serious enough, but just not in terms of the legislation. She's trying to qualify it. He didn't. He said there was no risk of significant harm. He said there was no evidence to give risk of significant harm. That decision is
final.
Everything that the Perth and Kinross Council did after that point was unlawful, because they'd gone before the judge and the judge says these allegations do not meet the threshold that there's a risk of significant harm. So the abduction, right, the conspiracy with the police, the getting you locked up and getting you to sign the bail conditions, the social workers that wouldn't leave your house, the whole 9 yards, the abduction of your son, was all unlawful because they'd already gone before the judge and the judge had decided on the evidence, all of the evidence, that there was no risk of significant harm. They have no case. And every time this comes up in the court, it's weasel words. I don't want to say this. I find that disgusting because it means they know what they've done.
One of the questions that was asked to the court was like, how do you justify a court throwing a process out on the Monday and come Thursday you're getting charged with the exact same allegations that a sheriff has thrown out? To which the comment was, it became serious. Serious for what? Police involvement. Police were already involved.
Yeah. You raise the issue here of John's welfare after he was taken from your care. You say to Shirley Douglas, can I bring one thing up? Didn't John suffer teeth problems when he was down in Glasgow? That he had to be taken to a dental hospital. She said, I don't know the ins and outs of the issues subsequently, but my understanding is that he's been receiving dental treatment since he's been in Glasgow. You said, who he is now, but at first it wasn't working. I was getting emails from Anne Prentice saying there was a problem with John. Can you tell us, are we brushing his teeth in the right way? Do you know anything about that? Right? So this is Anne Prentice reaching out to you, having abducted your son on the basis that you assaulted him with a toothbrush, realising that they can't brush his teeth, and they're contacting you and asking for advice as to how to brush his teeth. And her response, I'm aware that Anne Prentice kept you up to speed with John's welfare. Now, this is a garbage response. She wasn't keeping you up to speed with John's welfare. She was asking for your help with John's welfare. More weasel words. They can't actually say a single straight sentence almost at any point through this whole thing. Because there's so many things they're having to deceive about. Your cross of Shirley Douglas, which is a gold mine, continues. You say, I had Anne Prentice and Dinah Scott visit me on the 27th in the afternoon. Because it was true that I phoned and asked for a social worker for John. The witness was nodding. And they appeared in my house that afternoon. They were offering me services for my son John. John had been brought back to me. Shirley Douglas says yes. So there's further questioning, and Shirley Douglas says, and I also explained to you the reason why your son had been brought back to you that night, and that was because the removal order had not been granted by Perth Sheriff Court. Okay? And this is where you get her, because you asked the killer question based on all the allegations. She says yes. So what went into Perth Sheriff Court on Monday was based on all the allegations. Yes. And then you ask, but they still came back and took him away 3 days later. The same allegations. Is that right? Shirley Douglas says yes. And then she realises, I think, what she said. Because, as we discussed before, the court had decided there was no risk of significant harm on the Monday. The same allegations cannot be reason to remove your son on the Thursday. They just can't. And you go, thank you. And then Shirley Douglas, not in answer to any question, decides to lie. Because she says, under a different order. You go, sorry? She says, under a different order. You ask her, what order was that? She said, that was under the Adults with Incapacity Act. We'd applied for an interim order, which Anne, she's decided to lie, she's going for it now. We'd applied for an interim order, which Anne Prentice explained to you in detail. And I witnessed that conversation that Anne Prentice had with you over the phone. You say, when was that? She's like, I can't recall the date of that conversation. And you say, well, I can't recall it either.
I don't think so.
Anne Prentice became John's social worker on the 27th of August. The first time I met her, I took her to my house, showed her everything that I had in place for John. That was the first day, wasn't it? I met her on the 27th. She said, I'm not sure. When I phoned up asking for a social worker, a new social worker, I didn't even know that Jess Taylor was still John's social worker because I hadn't been notified of that either. Shirley Douglas goes, that'll be yes. So, let me just be quite clear what she's saying and what the implications are. Anne Prentice was appointed your son's social worker on the 27th.
Right.
She went to your house on the 27th. Yeah? On the 28th, your son was abducted by Perth and Kinross Council, and Shirley Douglas, under oath, admitted this action was based on all the allegations, the same allegations that had been thrown out of court on the Monday, the 25th. But she says, under oath, that it was under a different order. And that order had been explained to you in detail by Anne Prentice over the phone and witnessed by her. So that could only be on the 27th or the 28th. Did Anne Prentice phone you on the 27th or 28th?
No, she seen us on the 27th when she came to my house. She never seen me on the 28th that I can think of, because I was in Perth police station all day. Then I got home from there till 6:30, and then I went out for something to eat with my family. No, I cannot for the life of me remember. And then as I've explained to you, no social worker in this earth can serve an order on anybody over the phone. It's got to be served by sheriff officers.
Well, because of this statement, now, I mean, I'm now saying that my conclusion is that that's a lie, right?
Definitely, yeah.
I want to explain the reasoning, right? You skewered her, you got her to say Yeah, we went on to court on Monday and the court charges were thrown out. Yeah. Now there was weasel words about what had actually happened, but she knows what happened.
Mm-hmm.
And she knows that they were thrown out because the judge decided that there was no risk of significant harm. This meant that there was no reason for Perth and Kinross Council to be doing anything. You've got her to admit in court under oath that she'd come back with the same allegations and taken your son. I use the word abducted because that's what it was, but taken your son on the Thursday, and you say thank you. And she realises what she's done. And she says, under a different order. Right? And she then, you said, what? Under a different order. Under what order? And then she's away. She's away to the races, right? Initially, I was believing she was actually more or less on the level. We were asking Perth and Kinross Council for the other order. Show us the order. And we asked them and asked them and asked them. And it was strange the way they were saying no, because they would say no in such a way that suggested they might have the order, but never actually saying they had the order. There was no order, and we eventually got them to admit
we got
it.
the proof of that, yeah.
There was no order. It was just the bail conditions were the only reason they had to abduct John. It was just the bail conditions, there was no order. So you continue with this. I said Jess Taylor was John's social worker right up to when the allegations came through. She was still John's social worker. Response, Shirley Douglas, from Shirley Douglas, that's correct. Now, why would I phone social work on the 27th and ask for a social worker for John? Answer, I don't know. Clearly the point you're making is you believe that there was no social worker because Jess Taylor you had said you weren't happy with her. And then I did get a social worker at 1:30 that afternoon. She arrived at the house with Dina Scott to talk about getting a new package for John, to get stuff put in place for John. And then the next morning I'm arrested. Nobody talks, nobody had any meetings in the social work about it. Response from Shirley Douglas, yes, there were lots of discussions. Multidisciplinary discussions.
Another one, yeah, well, there's that word again.
Right, so there were lots of discussions. So we're talking, that is an admission that the decision to act in this unlawful way was multidisciplinary, high level within Perth and Kinross Council. So this is not some social worker going off-piste.
We knew that.
Right? And going rogue and going out to get you for personal reasons. This is a Perth and Kinross Council corporate decision because she said it. She said there was lots of multidisciplinary discussions about this action between the 27th, when everything was fine, and the 28th when you were arrested. And multidisciplinary also means multi-agency because Police Scotland were involved, as sure as you're there. So you bring the thing up again. You're not letting go. Good on you. You ask her again, Shirley Douglas. He was taken away again on the Thursday. She says yes. And that's what I was explaining. It was in terms of Adults with Incapacity Act as opposed to adult protection. In terms of the removal order, it wasn't that the allegations, it wasn't that they were thrown out. We had nothing to do with the criminal case. That was entirely a matter for the police. That's nothing to do with social work. What we did, we had the information that concerned us enough that we applied through the Adult Support Protection Act to the court to have your son removed, and that was refused. That is not to say that the allegations were thrown out, but at times you were aware that there was a joint police and social work investigation going on because I told you when I came out to your house on that date. Right, so we're panicking. Yeah. We're bits of everything in here trying to unpick this. So she's trying to suggest that there was a second order because she's talking about the Adults with Incapacity Act and the Adult Protection legislation, right? That's a lie, right? And she said it wasn't that the allegations were thrown out. Yes, they were. The judge decided there was no risk of significant harm. That's called throwing them out, dear. And he said we had nothing to do with the police investigation. He said, this is a matter entirely for the police. That's got nothing to do with social work. And then in the same sentence to talk about a joint investigation. She's all over the place. She's panicking. Right? And honestly, she didn't say anything there. You continue. So you're working hand in hand with the police at the time. You don't, like it was said yesterday, take a back seat and allow the police to get on with the investigation. Response: the police will investigate the criminal charges, but that's nothing to do with social work. But in relation to the welfare of your son, that will be our responsibility. But we would take our lead from the police in relation with how to work with you. We would never jeopardise a case. We would never ask you anything the police were already dealing with or discuss with you anything. That's why I suppose when I visited you in the first place, I explained to you that I wasn't in a position to divulge that information because it was a police responsibility and not mine. Several points. I suppose is a tell. I suppose means I'm lying again. Because she's trying to say that it was already a police matter on the Monday when they came, and that's why she wasn't telling you anything, because she was bound by that. The Perth and Ross Council were all over this investigation. They were talking to the carers, they were talking to the main witnesses. They couldn't have been more cheek by jowl. The police, it was a joint investigation. We've got it in writing, it was a joint investigation.
See, what I don't understand with all this rigmarole that they're talking about is how can a case become on a Monday thrown out, same allegations, same statements, till Thursday it becomes a criminal investigation. What made it become criminal?
Well, it can't be, because it was before a judge and there was no risk of significant harm.
So it was thrown out?
On the balance of probability. It can't possibly be suddenly on the same allegations, criminal beyond reasonable doubt. It's nonsense. We come to the 3rd December 2015. We've now got the testimony of Jennifer Shields, your daughter. She was first examined by Owen's solicitor, who asks, were you aware that Mr. Shield employs personal assistants to help look after John? Yes. Do you remember the names? Ashley, Debbie and Donna were the main ones I had contact with. Notice that she didn't actually interact with any of the other carers, or the ones that were fine with you. There was no contact there. Under what circumstances did you meet them? When I came up and picked John up in my car, the view was that we would meet in the car park and transfer to my car. Question: when John came from their car to yours, did you have occasion to speak to the carers? Yes, they made quite a lot of attempts to initiate conversations with us at the car park. I believe with indications over a period of time in 2014. So you then start to cross-examine your daughter. You say, now, here you're saying, I believe my father orchestrated John's removal from the Mallards Centre in Glasgow when he was 16 years old. I believe my father wished to take charge of all things with respect to John and to take any parenting rights away from my mother. Could you explain a wee bit more about what you were meaning by this? Right, so again, it's all about personal family hurt. It's not about John. It's not focused on John. Her reply: I believe you wish to have sole parenting rights of John and that you were willing to take him out of the Mallard to live with you full time, so ultimately you could have that. You ask her a question: is there a problem with the father wanting to look after his son? Her response: I can understand a parent wanting to look after a young person. However, I think John at this point was becoming an adult, and the plan was to work together to have John moving on to being an independent young adult. And there have been plans in school meeting where we were talking about John moving to his own tenancy and being supported, having supported accommodation. And that plan, I believe, was to have been with my mother wanting to have him and his independence rather than one parent wanting to have all the sole responsibility. And to use the words power and control over the young adult, that's a bit I disagree with. Okay. So it's nothing to do with care, it's nothing to do with assault, it's nothing to do with violence, it's nothing to do with abuse. It's to do with her and her mother wanting different arrangements.
That's basically what it is. I think I've talked to you before when she wanted me to share guardianship with the mother, which I refused. You know, the reasons John was removed from the mallard are there for everybody. I think I've already commented.
We've covered that in detail. So, that's what it's been about. There's a question that I have to bring up. Do you believe that being a father, it was wrong of me, finding out my son had been abused in the home, that it was wrong of me to take action to go and find out what happened to my son? It's an important question. Jennifer responds, I think there was a problem with your question in that you had a high suspicion that John was abused in the mallard, and the judge and legal advisor involved concluded there was no evidence to fundamentally say that John was abused in the mallard.
What judge?
Exactly. There was no judge, there was no legal advisor. She might be referring to the Glasgow City Council people who ran the investigation, but she's trying to spin it. She's trying to make it sound like there was a more thorough investigation than there actually was. And again, we've got the weasel words, you've got the tell word. She doesn't say, because people don't like to lie. People get nervous in lying, they throw in extra words. She doesn't say there's no evidence to say that John was abused in the mallard. She says there's no evidence to fundamentally say that John was abused in the mallard. That extra word, that's anxiety coming out, because she knows fine well that there is evidence to say he was abused. You and I have to say that this is not a subject that I chose to bring up when we were together. This is a subject that always came up from a younger teenager to the person who's standing in court here, and you believe John was abused in the mallard, and I sympathise with the fact that you believe that. I have not shared these views because I don't have the evidence to say that happened. I have to say that his behaviour was more settled, and he did learn to be in control of his behaviour, because that is how I recollect it. My perspective has always been different to yours, but the problem is is that you're not able to see things from other people's perspectives, particularly my own. That is my opinion on them. So it's about her. It's about her and your relationship with her. It's not about John. Right. She then feigns lack of knowledge of what you were convicted of. This is strange because all of the allegations came from her. Mm-hmm. Right? So you say that you don't know what the convictions were because no one gave you the information until now. Is that right? She responds, I've not had the details of the situation that surrounded what you were convicted of doing. You say you're trying to say that a year later you have no idea what I was convicted of. She says, I know what you were convicted of, but I don't know the details of what you have been convicted of.
That's a lie.
What you've been convicted. I don't know the situation in which it occurred. I don't know exactly what happened. I got a very brief description. And you start to go, well, and she says, sorry, she says, I'm still speaking. There's an attitude here, doesn't like that. I'm still speaking. I had the right description from the court piece of paper, and what I read was what I have been told, but I don't have any other details other than that. So all of the accusations came through her.
But she's denying knowledge.
But she doesn't know any of the details.
That's lying again in court.
So you said you don't know what I was convicted of. She said, I know what you're convicted of, but I don't have any of the details of the situation surrounding the event. You say, if I ask you what I was convicted of, can you tell me? She said, I can now, yes, I have just read that you whacked John with something. That's not true. That's not what you're convicted of. And vigorously used some sort of painful toothbrushing while you're forcibly pulling his head back. That's not true either, because you were acquitted of that, because that's best practice. So when Jennifer was being asked about the day where she had to return John to you, where the council's action had been thrown out by Sheriff Fowlis, the lawyer said to Jennifer, you were required to return John to your father. She said yes. You arrived at your father's house. She said yes. Could you tell the court what happened when you got there? Did you take John to the door? She said no, I didn't get out of the car. By the time he had already come out of the house and was standing on the pavement next to the gate. Is that your father? Yes, my father was standing on the pavement, and I got out of the car at that point, and he started to shout and was being unreasonable. certainly to the degree that John was finding it very difficult to cope again. So your father and his partner and John returned to the house. You and Mark returned to your car and presumably you set off south. I did. I called the police just after I left because of the shouting as we left the house. I was concerned about what John had been exposed to and for them to check that everything was okay. So you made this call and continued your route south. I asked the police and they asked me to come into at the Broxden roundabout and wait there for instructions. I believe they were checking on things. I was there for half an hour before they called to say it was okay. In that period, is your understanding that the police called at Mr. Shields' house and checked the situation? Response, my understanding is that they checked the house to make sure everything was settled and calm, and it seemed to be when they got there. Further on the cross-examination by John Shields, he tells Jennifer that there's no police record of a call being made to the police that night. Okay, now we've got the letter. We'll put this on the screen. We've got the letter from Police Scotland, and the letter from Police Scotland reads: "In your request, we were looking for confirmation as to whether a phone call was made to Police Scotland in relation to yourself, and if it was, why the police did not visit your address. I've been unable to trace any calls in relation to your address received on the evening of the 25th of August 2014. So the police have no record of this. Jennifer said there is a police record of it, and the social worker aware of it, of that police record, and my mother is aware of the police record. So all of that's just nonsense.
It's lies. She's actually put the social worker in a bad place as well.
She said elsewhere that she phoned the social work department. She may well have phoned the social work department out of hours to try and spread some more poison on the way back. But she never phoned the police. But here she is, under oath in a court, making stuff up because the police have no record of this. Now, did the police come to your house?
No.
Okay. So you on the examination, you say the police. You say you called the police and asked them to check if John was okay. She said yes. The police never visited me. She said, I know they didn't. They walked past your house.
Oh, that was it. Yeah.
Now, that is clearly a lie, because if police are going to do a welfare check,
They'll come in.
They'll come in. They'll see. They'll eyeball the person. In fact, they won't go away until they've seen the person. That's the whole point of a welfare check. 3rd of December 2014, Maureen Phillips, Panis, her testimony. Maureen Phillips was asked, can I ask you now that you know what the convictions are, do you believe Mr. Shields is a suitable welfare guardian for his son? So they've taken her through the convictions, what you're convicted of. They've put her on the spot. Knowing that, do you believe Mr. Shields is a suitable welfare guardian for his son? Maureen Phillips, I do believe he's a suitable welfare guardian for his son. So this obviously wasn't to the liking of the lawyer. Having assaulted his son on 2 occasions, Maureen said, I think he's been found guilty, but I'm not sure if I would. I know he's been found guilty, but I'm not sure if the evidence that led to that was a full investigation.
Well, she's telling the truth about what we are talking about, this investigation.
So the solicitor continued to push the point. Maureen responded, on the basis of this then, if you're saying beyond reasonable doubt to me, I'm still not sure of the evidence that was presented to make them say beyond reasonable doubt, I'm still not convinced. The solicitor was not willing to give up, continued to push.
He did, I remember that.
And she said, if I had access to all the evidence, I could make a decision. Then the decision was this, then obviously I would agree with it, but I'm not convinced that all the evidence was presented in the right way. So by this point, the solicitor's getting really anxious to get something said. So he says, so again, talking hypothetically, if we have a person whom you know has committed 2 assaults of violent abuse on an adult with profound learning difficulties, is that not a suitable welfare guardian? Maureen responded, no, if it's clear beyond reasonable doubt, the evidence has to be clear. So Maureen wouldn't budge.
No, she was never going to.
So Ellen Houston, carer for John 2005 to 2010, was examined by you on the 4th of December 2015. You said, was there any application ever from from John's mum and sister at that time to take John on holiday or anything like that? No. Did they ever approach you when you dropped him off? No. So they just never had any rapport with you. She's never had any communication with me whatsoever, just picking up and dropping off. You said, are you horrified at the terms of the assaults now that you're aware? She said, I'm horrified of what you've been accused of, yes. Yes, he's been found guilty, but in my heart I can't see it. I'm sorry that he's guilty, I can't see it. I'm sorry, I just can't. So she wouldn't believe you were guilty either.
No.
Now, that takes us through the hearing. And there's then a long pause, because how long does it take the judge to come up with a decision?
I think it took 9 months to make a decision on where John was eventually going to go and who was going to be guarding him.
So during this, we've got on file, we've got John at this point down in Glasgow with his mother and his sister. And again, we're now getting reports of bruising, fairly minor bruising, nothing like the mallard, but again, bruising on his upper arms. And there's some investigation and no one knows where the bruising's coming from. And we're back to having minor bruising and sufficient to have a bruise chart so that we record the bruising as it goes along. So there's concern again, never in your care, but there's concern again with minor bruising.
I think he was put in adult protection while living.
It was it was at least considered, I think.
No, he was put on it.
Oh, yeah.
He was put on adult protection because of issues that had happened down there where the care company were getting the blame and they were fighting back saying it wasn't them that had done it. And before I knew it, an application had been put forward by Glasgow City Council for an adult protection order to be placed on John. That's while he's living with his mum.
Yeah. And we're getting all these, Gillian Morrison from Perth and Ross Council's writing to you. Firstly, I can assure you there's no cause for concern, but she's updating you on bruising, she's updating you on a near miss with medication. And then we come to the 2nd of December 2016. So we're 2 and a bit years in now from when it all kicked off, 2.5 years in when it all kicked off. The judgment of Sheriff W.M. Wood. The Sheriff, having considered the application and productions and having heard the parties thereof or proof, grants the application of the 2nd and 3rd Ministers, that's Perth and Ross Council, your ex-wife and your daughter, in terms thereof, and appoints Mrs. Kathleen McJimsey and Jennifer Shields as joint welfare and financial guardian to John William Shields, born 25th August 1983, in place of John Stuart Shields for a period of 5 years from this date. And then you decide to appeal this. So the 4th of January 2017, you lodge an appeal against that decision in front of Sheriff Principal Lewis. So what was the appeal like?
Sheriff Principal Lewis was very good with me. First of all, she stated when I went in there after reading all the documentation, etc., she kind of hit me when I wasn't expecting. A request that she made was, what would you like me to do with your son? And I didn't know what she meant. What she was actually saying was, she was wanting to give me my son back. And I had to look at my wife, Janice, and say, is she saying what I'm thinking she's saying? She's asking me, what do I want to do with my son? I didn't think that's what we were here for that day. I didn't think that's what the appeal was. But that's what she started with. And then I had to turn around and say to her, look, Your Honour, I've came here today for an appeal against a decision, but you're hitting me something I wasn't ready for. I says, and one of the worst things about whether I got my son back was I would have to deal with Perth and Kinross Council, of which I am not ready to do. So she kind of turned round and she went like, well, I think what we'll do is we'll leave the status quo. Right, we'll just leave John where he is at the moment. And she started questioning areas of the criminal case, etc. She started talking. And then the strangest thing that day happened was that after going through statements she made, the two lawyers, one for Perth and Kinross Council, Adam Heath, she made him stand up. She went to, I think it was Docker, his name was, Docker.
Docker.
Was a solicitor for Morrison, who was representing my daughter, my ex-wife, and she made him stand up. And I'm sitting there and I'm like, I'm like, Beltrami, what's happening here, like? And I turned round and here's these two lawyers standing there. And then I looked up and she got up, she just sat there and she battered these two lawyers. She turned and she says to them that she had read my case, and for which she read that all she seen was supposition statements and hearsay statements against me. She says, I can't see anything that this man's meant to have done. And she turned around and she says to me, isn't that true? It's pure and utter hearsay, that was the word, hearsay and supposition. And do you know something, David? I looked at these two lawyers and they turned around and they went, yes, ma'am.
Well, Adam Heath, representing Perth and Kinross Council, admitted to Sheriff Principal Lewis that they'd fabricated a case against you from half-truth suppositions and false statements.
100%. That is what he said. What she did say was, I would be back in court. She said I would be coming back to court. And that day, me and my wife left there absolutely shocked. We couldn't believe what had happened that day.
Well, by the 26th of April 2017, she issues her, so that's from January. 26th of April 2017, she issues her decision. She says, Sheriff Principal, having heard parties, dismisses the appeal. In a judgment, Sheriff Principal Lewis states that in any event, the appellant cannot get around the simple fact there are two extant convictions for assault, both of which predate the current proceedings. The appellant was convicted after trial of two assaults on his son. No appeal was taken against either conviction, so this has been held against you. You didn't appeal, although your lawyer wrongly advised you could not. The sheriff was therefore entitled at the time to rely upon those convictions as demonstrations that the appellant was not a suitable person to remain welfare guardian for his son. Right, so it's all those two convictions, that's all they have. The sheriff carefully balanced the convictions against the determination of the appellant as shown in relation to care of his son to ensure the best and most appropriate care packages were made available. He is to be commended for his fortitude. I did not accept that the appeal was doomed to failure or that it was frivolous, because this is what the other side was saying. In the midst of plainly unarguable points, the appellant did highlight matters that can properly be regarded as potential errors of law. However, he was not successful in persuading me that the sheriff had erred in law and that he came to the appeal with no clear idea of what he sought by way of outcome, which is what you were saying. In those circumstances, he has to accept the consequences, and accordingly I find the ministers entitled to the expenses occasioned by the appeal. So that was that back in 2017. Any further thoughts on this before we go on to more recent matters?
I've reiterated to a lot of people, dealing with Perth and Kinross Council is my problem. If I bring John back to this area and look after him, if I want a court proceeding to bring John back, I've got to deal with them. How can I deal with a council that's treated me the way they are, lied the way they've done? They had nothing to take John away. They made everything up as they went along. They got desperate. Really desperate with me.
So what then happened, just to let people understand, is we got together, we started to push and we started to uncover the story we've presented. There's one more episode of this to come, but we're almost up to date in the main story flow. So we discovered how your son had been taken, what the legal basis was and wasn't, and we discovered there was no order, and we discovered all of these things, and we pushed Perth and Kinross Council, and we got quite a lot of information, even though they tried hard not to give it to us. And we started raising questions with Police Scotland about their conduct and raising questions with Perth and Kinross Council about theirs. But on the subject of guardianship, that guardianship, well, the guardianship decision ran from 2016 for 5 years, which has obviously expired. But expired during COVID, so there was a lot of delays and what have you. And several odd things happened. You've got a form, you've got a document that says you're guardian until 2029. It's never been rescinded.
No.
You've never signed anything to say you're accepting someone else as guardian. And it appears that the court, after taking nearly a year to come to a decision, didn't issue any paperwork. We'll come to that in a minute. So we started digging around what's been happening more recently. So 11th of March 2024, I contacted Glasgow Sheriff Court and asked whether or not a guardianship renewal hearing took place on the 15th of February 2022 under the Adults with Incapacity Act for John William Shields. We'd managed to find out something to suspect that had been the case. You'd never been notified. Glasgow, 12th of March, Glasgow Court came back and said that a hearing had taken place on the 15th of February, but you'd not been notified. 12th of March, further requests went in regarding the hearing, looking for case reference numbers and stating that you were an interested party and asking why they'd not been contacted. Glasgow Sheriff Court replied they were unable to provide any further information, suggests contacting McNairs and Wilson Limited solicitors, presumably solicitors to your ex-wife and daughter now. They were contacted. They came back and said that they were not authorised to provide any information. Glasgow Sheriff Court were again approached and advised that McNairs and Wilson had declined to assist. They were asked for the following information. Was a motion put before the court on or before the 15th of February 2022 to dispense with intimation, that's telling you about the proceedings to Mr. Shields? If such a motion was not put before the court, on what basis was the decision taken not to inform Mr. Shields of this action? If a motion to dispense with intimation was put before the court, please provide a copy of the justification offered. Please provide a copy of any interlocutor issued by the court in connection with this case. 21st of March, Glasgow Sheriff Court replied, having taken advice on this matter from our Freedom of Information Department, we can advise the following. We are unable to provide the information requested. It is for the Sheriff to make a determination on who they consider to have an interest in any given application. The basis for this decision would not be recorded and would therefore be inappropriate for Scottish Courts and Tribunal Service staff to comment or provide any information in relation to a judicial decision. It's secret.
Yep.
So there's been a hearing, we don't know what. We went looking for information and we found that there was really no paperwork. And this is very, very strange. So just to illustrate this finally, where we're standing at the moment. This is the letter John sent to the Chief Executive of the Mental Welfare Commission for Scotland, who regulated the oversight of all these matters. A Miss Julie Patterson. This went on the 1st of March this year. It reads, Notice of Understanding and Declaration of Intent. We hereby give notice that we understand that 1. John Stuart Shields was appointed as Welfare and Financial Guardian for John William Shields on the 11th of September 2009. 2. The appointment was for a period of 20 years, i.e. until 11 September 2029. An interlocutor guardianship renewal order was issued by Sheriff Fletcher in Perth on 11th September 2009, confirming this position. The case references AW 4809. No other order, interlocutor granting guardianship to any other party has been issued by any competent court. True. And to the very best of ability, and we really have tried, that's accurate. We cannot find any. John Stuart Shields has never voluntarily surrendered his guardianship. Another party is presently administering the guardianship without clear legal authority and contrary to the wishes of John Stuart Shields. Consequently, we declare that 1. Mr. John Stuart Shields remains the legal guardian of John William Shields. Mr. John Stuart Shields reserves the right at any time of his choosing to put all the facts of this case before a competent court to seek restitution and compensation. Mr. John Stuart Shields requires the Office of the Public Guardian to provide full, detailed and comprehensive report on the health and welfare of John William Shields, or else provide a lawful excuse why they are unable to do so. Mr. John Stuart Shields requires the Office of the Public Guardian to provide a full, detailed and comprehensive report on the financial affairs of John William Shields, or else provide a lawful excuse as to why they are unable to do so. Mr. John Stuart Shields requires to see his son and instructs the Office of the Public Guardian to arrange a meeting or provide a lawful excuse why they are unable to do so. So that went in March. What was the reaction?
It's a hard one. Nothing.
Nothing.
No reaction.
No reaction. No reaction, and when chased, they claimed to have never received the letter.
Oh, the letter was lost. I've been told that a phone call has been recorded for use, would be put to the boss of the mental welfare, but nothing has happened.
And obviously we've sent other copies, and so far, complete silence. Now, of course, in legal terms, he who is silent is taken to agree.
Yeah.
So we must conclude that the Mental Welfare Commission agrees that you are in fact legally still the guardian for your son.
They've no said no.
We can't find anyone who'll say no. We can't find anyone who's got any documentation. The whole thing has been done on a nod and a wink, and possession being 9/10 of the law.
To cover up bigger issues, I expect, David, that this has been done. It's shocking. It just shocks me.
So, just to close off, we've been through your long rearguard fight against the removal of the guardianship. That fight actually goes on because they have no paperwork.
Yeah.
Oddly and bizarrely, there is no paperwork, there's no interlocutor, there's no order. There's all these, there's requirements in the Act about who's to receive the interlocutor and who's to then issue certificates, and none of it appears to exist.
It doesn't, there's nothing, absolutely none. It's bizarre. I think when you state a case like this is bizarre, people would never understand, what the rules for this just don't seem to exist. Like in this country, they just come take a child away. They don't need rules. They don't need any regulations to do it. They can just do it. That's what this boils out.
Yeah. And that's exactly the point. That what this case raises is wider concerns about the entire way the police operate, the entire way that local authorities operate, the nature of social work, the nature of social services, the interaction between the police, the fact that the police work with local authorities and therefore local authorities are, for all practical purposes, above the law, and the abuse that comes from that.
Yeah.
We have, as we mentioned before, the confirmation from Perth and Kinross Council that we're operating based on no legislation.
Nothing at all.
No operating procedures, no rules, no regulations, no nothing. It was all made up on the spot to get you done. John, we have one more episode which will be looking at the political aspects of this, and it's going to be called the John Swinney Connection. Until then, John Shields, thank you very much.
Thanks again, David. Appreciate it.